number 84, Deutsche Bank. Counsel?
May it please the court, Doug Hallward-Driemeier for the trustee on behalf of the trusts. I would like to reserve 3 minutes of my time for rebuttal.
Of course.
Your Honors, this cause of action is timely if it accrued in New York under New York law, and it is timely under California law if it accrued in California. The only way that the First Department determined that it was untimely was by Frankenstein monster type.
You say it's timely in California. Do you mean it's timely under the discovery rule in California?
We have two reasons. The discovery rule certainly is true, but also because of the accrual.
Can it be timely without the discovery rule being applied?
It could because of the accrual
so?
rule. The California courts apply an accrual rule that is different from the rule applied in this state. California would recognize the party's ability to contract for a later beginning of the statute of limitations. And in the BR1 case, there is an explicit accrual provision that's the same as this court considered in Flagstar. In Flagstar, of course, the court ruled that under New York law, New York would not give effect to the choice to run the statute of limitations from.
Can you have a cause of action until it accrues?
The cause of action, I think the accrual and the cause of action are simultaneous.
So I guess I have a hard time understanding why accrual would not be a question of substantive law that would, under the provisions here, be New York law in these cases.
Your Honor, the rule in California about the ability of parties to contract about accrual is part of their procedural law.
Well, I understand that, but there's a New York choice of law provision here. And if New York says it's substantive, then why wouldn't that be controlled?
Well, in the DLJ case, Your Honor, the court addressed the fact that the conditions precedent is a procedural rule. And for that reason, Section 202 would pick up the rule of another state with respect to conditions precedent. And so the rule in California, procedural rule of condition precedent, is what has to happen before the claim can be brought.
Can I just,
Go ahead.
sorry, could I just leave California aside for a second and tell me, if you can, what's wrong with this? It's sort of a very simplistic approach. 202, CPLR 202, applies if the cause of action accrues outside of the state. With me so far?
Yes.
We said in ACE and in Flagstar that the cause of action accrues when the MLPA is signed.
That's right, Your Honor.
When and where was it signed?
In this case, the MLPA was executed in New York. It was the closing occurred in New York.
Why doesn't that just end this?
Your Honor, we agree that the cause of action accrued in New York to the trust because all of the activities that are relevant here.
I understand that argument. I'm not sure why you even need to go through trust, trustee, et cetera. Don't we have holdings in ACE and in Flagstar that say for an RMBS case, the cause of action accrues, if the representations and warranties alleged to be false, the cause of action accrues the date that agreement is signed.
That's right, Your Honor. That's the date.
Okay.
And also, ACE also specifies that it is the trust that is in it, and it is the trust that sustains the legal wrong at that moment of closing. And the trust is created under New York law as a New York express trust. The settlor is a New York entity residing in New York. It creates the trust in New York on the date of the closing, and all of the representations and warranties are made here as well.
In order to go the way that you want to go, it seems our choices are either we have a plaintiff residence rule or we have a Madden-like factor test, and you advocate different factors. Is that correct?
Well, where the plaintiff residence rule is stated in Global Financial as the usual rule, because usually the plaintiff is suing for its own injury. But Global Financial actually references by a CF a counterexample, the Lang case, in which the injury was suffered in a
That's the
place other
financial
than
impact
residence.
rule. Is that what we're talking about?
It's the injury to the party whose wrong is being advanced. And
And
here,
one of the difficulties in this case seems to be the distribution of the economic injuries that makes that a more difficult argument to make.
well, Your Honor, it certainly makes it a more difficult argument to make that it's the plaintiff's place of residence, because the plaintiff, the trust, doesn't stand to lose anything on the breaches of the representations and warranties that are the subject of this
One of
suit.
the things we struggle with is the balance between uniformity and consistency, and which you get from a plaintiff's residence rule, and but you also get inflexibility to deal with variations between different litigation. So what happens is when I look at something like this, I say to myself, why is this action brought on the last day of the 6-year statute of limitations? I mean, you'd have to be living in a hole not to know that this action should have been brought sooner.
Well, Your Honor, to the contrary, with respect to the discovery rule that California would apply, for example, you have to take into account all of the circumstances. And here the circumstances include the fact that the defendants made representations and warranties. They said that the trustee may conclusively rely on the representations and warranties, and they specifically said that the trustee has can only do those things that are obligated to do under the agreement, and then moreover underscored that it has no obligation to investigate the underlying documents.
When was the forensic evaluation done of the mortgages that were involved here?
The forensic examinations were done, I believe, shortly before the demand was made on the trustee to file suit. The forensic
So let me just, so I have a time frame in my own mind. So is that 4 years, 6 years after the economic meltdown in 2008?
Well, Your Honor, yes, it was many years after, and of course the economic meltdown is only the general economic situation, but that's not a basis of a cause of action. There has to be a breach of the representations and warranties about specific mortgages, and that required a loan-by-loan, essentially
Were there ever any actions brought against Deutsche Bank for breach of any fiduciary obligations for waiting for such a long period of time?
Excuse me, Your Honor?
Were there any actions brought involving these mortgages for a breach of fiduciary obligation against your client as a result of this?
No, Your Honor, and none could be, because specifically under the agreement, the trustee has no obligation to investigate, and it specifically is not to take anything that is not obligated to take.
Give me your best estimate. If the California discovery rule were to apply, would you fall within the statute of limitations, and how do you think that would come out? What do you think that it's possible that discovery would show? I'm just asking you
Your Honor,
generally.
Specifically in April Enterprises, the California court made clear that the statutory period starts to run upon discovery or when they should have discovered. Mm-hmm. So as long as with reasonable diligence, you would not have discovered by 2 years after, by 2009, mm-hmm. then the action is timely in California. And of course, I know that Your Honor is pointing to, and the First Department certainly pointed to, the general economic situation. But remember that in these documents, New Century had already declared bankruptcy. So these defendants said, don't worry about that. We ourselves are going to look at these mortgages. We are going to represent and warrant to you, not New Century, that these conform. And on that basis, the trustee was able to rely conclusively on those representations, did not have any obligation to undertake an investigation. And so
Does
as
that
long
mean
as
that they could not have discovered these breaches? Which, I mean, I read the California rule being a little more strict, which is saying it has to be that it was secret, that it was hidden, that there was no way with reasonable diligence. Now, you say we weren't required to exercise diligence, but I don't see the California rule speaking to that. I see it saying, could they have done it reasonably?
Well, Your Honor, both in the Marin case that they cite and the Kaplan case that we cite, it's clear that it is a matter of context. And the context includes, for example, what the agreement says. In Kaplan, it was at any time. Here, it is a specific provision in the agreement that says the trustee has no obligation to inquire and may conclusively rely on the representations of the defendants. At the very least, it would be a question of fact. In California law, it's clearly a factual question whether one has acted with sufficient diligence. And
Let me get back for a second, though, to the whether it should be plaintiff's residence or the multi-factor test. So it seems to me that there's general agreement that those who are really being economically harmed are their certificate holders, but that it would be completely impractical to base where accrual is on that, because they're so that the alternative to that is either stick with the plaintiff rule. Why not? It seems to effectuate the purposes of our borrowing statute, or we go with this multi-factor test. And what we have here is 3 very sophisticated, very well represented companies, all arguing for different factors and which ones are more important, and if we apply these factors, then it leads to one result, and if we apply these factors, it leads to something else, which seems to me to contradict completely the certainty and the lack of forum shopping that the statute was meant to achieve.
Well,
so why would we go that way when we never have in this kind of case? And
Your Honor,
we have a perfectly acceptable alternative.
Your Honor, I'll point out that in Global Financial itself, the court did not resolve whether it was the principal place of business or the place of incorporation. In the First Department, they have held that in an instance of a corporation that isn't really active, you would look at the place of incorporation. That's the analogy here. You have a trust that is not itself particularly active. It is created in New York under New York law at the date of the closing. Everything is happening in New York. The representations are being made to it, conveyed. It's a specific, separate asset of the trust in New York. It's being breached in New York. The certificates are being issued in New York. The securitization
Well, now you're talking
is
about
happening.
the factors.
Well, Your Honor, but
You're beyond the place of incorporation. So are you suggesting that the rule should be the place of incorporation?
I think in an instance where you have an entity that is not itself conducting business, the place of incorporation makes the right sense. And here, the equivalent of that is New York, because it is New York law under which this trust is created.
So the rule you're proposing is for a New York business trust created under New York law, that's the factor you would look at to the exclusion of all else.
I think that's right, Your Honor. Of course, here, it's a little easier because all of those factors point to New York. Everything that the other side is pointing to is all post-accrual activity. ACE made clear, as Your Honor pointed out earlier, that it is the closing date that is the date of accrual, and all of the activity in California happens post-accrual. So that is really irrelevant.
Right, but what I'm getting at is, I take Judge Stein's point, which I think you ought to take as well, that a clear rule is a lot easier for commercial parties to think about than a rule that looks at a whole bunch of different factors that can be weighed who knows what way. And so part of the time I'm hearing you say, well, there's a bunch of different factors, but another time I heard you say, look, this is a New York trust that is, you say not functioning, I say a business trust, created under New York law. Is that rule sufficient for you? Because that's a clear
rule. That rule is sufficient, and it is clear, Your Honor, has the benefit of clarity, absolutely. I merely was saying that in this case, the court may not have to adopt a specific single rule because all of the factors occurred here, but the rule Your Honor identifies is consistent with Global Financial, which left open that question. It's consistent with the case law in the appellate courts that have held that where an incorporated entity is not functioning, you would look to the place of incorporation, and it is a clear rule, Your Honor.
Thank you, counsel.
Could I, Judge, would you mind?
Yes, of course.
It was all right if I just did one. If we disagreed with you, we adopt 202, we say that California law applies, but since the discovery rule may apply, would we have to send it back to Supreme Court for fact-finding on that issue?
Yes, Your Honor. There are many disputed facts as to the reasonableness of the trustee's activity.
I see. Thank you.
Thank you,
Thank you.
counsel. Counsel?
May it please the court, Nick Boyle from Williams & Connolly for HSBC Bank respondent. CPLR 202 turns on the place where a cause of action accrues. And Global Financial,
Okay, so who suffered the injury, or what suffered the injury?
the trustee in this case suffered the injury.
How is that?
Well,
Did the trustee invest? Did the trustee
the
put
injury
their skin in it, as they say?
the injury at issue in this case is a breach of representations. The representations flow to the trustee.
Well, except that we say in ACE, this is the same question I asked earlier, which I'd like you to address. I mean, I don't have to restate the question if you know the question.
So in ACE, Your Honor asked whether the breach, if it occurs in New York, should be dispositive, because ACE says the breach occurs when the cause accrues when the breach occurs.
The cause accrues when the MLPA is signed, and that's what Flagstar says as well, when it's executed.
Well, I understand ACE and Flagstar to say that the cause accrues upon the closing of the trust. In this case, that was later than the MLPA, at least in the case of HSBC. It was a month.
So your point is that may be the timing, but that's not the location?
Well,
Situs of the
our
accrual?
point is, for example, in Global Financial, one of the factors considered by the court and rejected was the place of breach. When in Global Financial, one of the 4 factors that pointed to New York was the place of breach. The place of breach does not tell us where the place of injury is. In this case, it's a repurchase action. It's a repurchase of loans based on the breach. The repurchase...
But the certificate holder is the one that's invested, right?
That
The
is true.
certificate holder, if they now try to turn in these certificates, or whatever might be the appropriate vocabulary to explain what I'm trying to explain.
Yes, Your Honor.
They're the ones who are not going to get as much money back, correct?
Well, that is true as a consequence, but there's a contractual right at stake in this case. It's the repurchase right. The party to the contract is the trustee, it's not the trust.
Yeah, but the only point of that is so that the certificate holder, either their injury is mitigated or they suffer no injury, right? I mean, the trustee, it doesn't matter to the trustee in that sense. They're not, what I'm saying is, if the focus is economic loss, I'm still not clear how the trustee suffers an economic loss. I understand your point about the entity, the trust, right? So it's a fictitious entity.
As we understand the case, the trustee is suing because loans don't conform to certain characteristics. There's no allegation, for example, in the complaint that the trust suffered some economic harm.
Yeah, but it's purely for the benefit of the certificate holder, right? Individual
Excuse
or
me.
whatever entity invested. They're the ones who are not getting as much because you've got the crash.
But the trustee is the entity that holds the loans. The trustee is the entity that has the contractual right to loans with certain characteristics. And the complaint is, we, the trustee, are not holding loans with specific characteristics. We are suing to enforce that right. And in this case, it is a specific performance case.
I don't want to beat a dead horse, but let me just try this one more time. In ACE, we say the trust's claim subject to the 6-year statute of limitations for breach of contract actions accrued on March 28, 2006, when the MLPA was executed. In Flagstar, we say essentially the same thing. And in ACE, the PSA and the MLPA are executed on the same date. That's not true in Flagstar. The PSA is executed substantially after the MLPA, and we still say it's the date that the MLPA is executed, not when it's closed, executed, that the cause of action accrues. So I continue to wonder why 202 applies here at all, because we have 2 of our recent decisions saying that a case, unless there's some distinguishing fact about these contracts, that it's different from the ones there, I don't see why we're talking about 202 at all.
I think there's at least a couple of reasons. The trustee is not a party to the MLPA. So the depositor and the sponsor...
And wasn't in ACE and Flagstar either.
Well, but if we are looking to that as the time, then that's more than 6 years before the case was filed, because the MLPA was signed a month before the closing. And secondly, Deutsche Bank, in footnote 3 of its brief, has said it disclaims any argument that it's looking to the depositor and the timing of the MLPA, I think because that would be dispositive as to the case. But the trustee, as we understand it from the complaint, is suing based on the restatement of those same representations that are in the MLPA, which are restated as of the date of the closing date. So that is why it is undisputed in the briefs that the date of the closing, which is June as opposed to May, is the correct date. Now, if Your Honor is correct that we should be looking to May, it's more than 6 years. Even in New York, then the claim would be untimely.
Where's the location of the closing?
The location of the closing is in New York, but the representations are made to the trustee, and the trustee is in California.
Thank you, counsel.
Thank you.
May it please the Court, Jeff Scott of Sullivan & Cromwell for Barclays. Just going back to Your Honor's question, Your Honor is focused on the conduct that caused the injury, not where the injury was felt. And New York law has been clear for decades. It adopts the lex loci rule, where you look for the place of accrual, not when it accrued. And the way that the courts in New York do that under Global Financial and other cases is they look for the place of injury. And what this court found in Global Financial was that because it usually occurs where the plaintiff resides, they wanted to adopt what the court called in the penultimate paragraph the place of single determination,
Okay,
which
so
is
where's the injury? What's your argument for where the injury occurs?
the injury in this case clearly, and the plaintiff here argues, finally in its reply brief, it comes to a resting place, that the entity that was allegedly injured was the trust. Well, we know under longstanding New York law that the trust does not have a tangible location. In fact, what New York law says is that the trust is not separate from the trustees. It is where the trustee resides. So if the trust was in fact injured, it was injured where the trustee resides, and that's the place of injury. In the Barclays case, the trust corpus, the mortgage notes and loans are maintained in
What's
California.
the injury to the trust?
The injury to the trust here is now they're the legal owner of assets which have diminished in value as a result of the breach of representations.
The asset?
The assets here, and let's be clear on this, they talk in their papers all about the certificates and the beneficial owners. None of that is trust property. Not a single piece of that is trust property.
But the whole point, look, but the whole point of this particular financial device and the way it's used, and of course the impact the meltdown had on so much of the country, is that the certificate holders are the ones who now don't have as much value. Isn't
Right.
that? They're the ones, if you really look at global financial, where's the economic loss? Who or what is suffering the economic loss? It's not the trustee, it's the certificate holders.
Right, as Your Honor knows from the various...
I understand the argument that it's not a workable, right now under global financial, wouldn't be a workable rule to look at every single certificate holder's place of residence, but this is my problem with this case. That's who no longer has the same economic value that they had pre the crash.
So there are, thank you, Your Honor. So there are two types of cases. There are the RMBS investor cases, and this court knows all too well about those. That's the case you're talking about. They sue on the certificates for injury to themselves in their individual capacity because they suffered the injury. The trust here, as they admit in their papers, is suing on behalf of the trust corpus, which is located in California, and the reason it's located in California is because that's where the trustees' operations are and the activities. And they are not, the trust is, you don't make a persuasive legal point by saying the trust resides in New York because there's a New York choice of law provision. It's not a tangible entity. It's not a legal entity. It resides where the trustee resides.
Where is the injury?
The injury here is it's manifold. So injury to the certificate holders.
No, but where would you identify the geographic location of the injury, the economic injury here, say in the context of the Lang case? Where would you identify it?
I would locate it here in California where the trust corpus is sitting. The mortgage notes and loans are no longer of value in California. They're of lower or diminished value. It's where the trustee is located, and this non-tangible entity called a trust is under the case law resides. It's at the same location as to where the trustee is. So
I understand. The trust is in California. We all agree on that. Now, but moving beyond that, what I'm trying to get to where the injury is, and it seems to me that the injury here, if it's not in New York, is dispersed throughout the nation through institutional investors that cover all the states in the country practically. So it can be one of three places. It's everywhere, New York or California. Where do you say it is? You say the injury is in California,
I would
correct?
say the injury is in
And
California.
let me just finish the question then. What basis are you saying that? Tell me what the injury in California is.
The plaintiff here is the trustee. They're purporting to say the injury was to the trust. The trust corpus in the Barclays case is located in California. The injury is in
So what was the
California.
diminishment of it? Give me an idea of what the nature of the loss
The
was.
mortgage notes now and loans are less valuable because the credit characteristics with respect to the borrowers, the property which they allege, are no longer as
Properties
valuable.
are all throughout the country, so.
Right, and so the mortgage notes are no longer as valuable. That's the asset that generates the principal and income that gets paid to the beneficiaries. The beneficiaries are taken care of in the RMBS investor cases. And in those cases, Your Honor, just to be clear, all of the courts, the lower courts, found that the injury in those cases was where the beneficiaries were located because they were suing on the certificates. But here, the certificates are
Okay,
not trust
so
property.
let's say we go with this. How is the trustee enriched
They are not enriched.
by this arrangement?
They are not.
'Cause
They,
at the end of the day, then, whatever fee they may charge, I'm not talking about the fee. It's the certificate holders, right? Who, whatever investment they have rises and falls with this market and how these mortgages play out.
The trust here is the legal owner of assets that are now diminished in value. And in the case cited, the Toronto General Trust case, it has long been held in New York. No one has reversed that case from 1898, that the right to sue is in their
Who owns
own.
equitable title?
Pardon?
Who owns equitable title?
Who owns equitable? The beneficial ownership interest resides with the beneficiaries,
Right.
which are the certificate holders. The legal interest resides with the trust. And that's
So
why.
why should we not be looking at who actually, as global finance instructs, who actually suffers the economic loss? Because it's the equitable holder.
And our point is, there is multiple loss here, including to the trustee. The trustee is now, injury is defined in Black's Law Dictionary
ask you
as
this,
a
if-
wrong committed, sorry, Your Honor?
That's okay. If all of the beneficial owners were located in New York, would you still say it's either the trustee or the trust corpus? I'm not sure which now is the rule you're saying we ought to adopt. It would be California, even if all of the beneficiaries are here.
They have a separate injury, which they can bring in their own right on behalf of the actual certificates, and they did that. They filed hundreds of cases in New York State, and so their rights are protected through their action. We're
Can-
talking about a different action here.
I'm just going to ask you to shift gears for a minute before, I know your light's
Yeah.
not on yet,
Right,
but it
almost.
probably will be soon, and just ask if you would be willing to address the discovery rule.
So I think the discovery rule is quite easy. And I think, Judge Wilson, you were,
Fahey.
oh, sorry,
Wilson.
sorry, you were focused on, in your question, did they comply with the discovery rule? And the answer is absolutely no. There is nothing in the complaint. They say there's these factual disputes. Well, we know under California law that they need to plead and prove reasonable diligence that they undertook during the limitations period to actually discover. Now, what they knew here is the trusts were suffering hundreds of millions of losses. So they knew there was injury. And what California law says, and it's crystal clear, and that's why the First Department was correct, you have to plead, you exercise reasonable diligence during the limitations period. And they don't say one thing
So
that they
during
did.
the 4-year limitations period, it has to be pled.
Yes, that they took one step. They haven't pled one step they took. And what they say, and this is telling, the trustee really didn't want to get involved in litigation. So they point to the
Why is
provision.
that? Why-
Because what they say in their papers is there is a contractual provision that says we have a limited duty of investigation and don't need to investigate unless the certificate holders give us a direction. But nowhere in their complaint have they alleged, in light of the massive injury that the trusts were actually suffering, did they reach out to certificate holders and say, indemnify us and give us an instruction to investigate so we can pursue the claims of the trust. Instead, they remained silent until a certificate holder stepped forward after the statute of limitations in California had expired. And because they didn't take any steps, the contractual provision doesn't excuse them from compliance with California law. If they want to rely on the
I
discovery
agree
rule,
with you on that. What about their alternative argument about the tolling?
the accrual clause, and I see my time's up, but let me answer this question, because I think Your Honor was mentioning this earlier. There's this whole phrase, mixing and matching, that the First Department somehow mixed and matched. Their argument is not based on California tolling or accrual law. It's based on New York substantive law. And the reason we know that is because they're not looking to the discovery rule or some common law with respect to accrual. What they do is they look to the contracts and they say, these contractual provisions, the accrual clause in my case and the repurchase protocols in both cases, they mean this under the law, that the claim is accrued, but the contracts have New York choice of law provisions, which are substantive choice of law provisions. So if the trustee had brought this case in California, a California court would have said to the trustee, so I see your argument is that this accrual clause and this repurchase protocol toll it because they're condition precedent. But I also see that the parties selected New York substantive law, so I need to look to New York substantive law as to whether or not these provisions actually delayed the running of the statute of limitations. And that's an easy...
Is that what you think the legislature and what we've interpreted 202 to anticipate?
Well, with respect...
That one is going to look to the non-New York state, obviously, right? The other state, the other jurisdictions, statute of limitations, and then look back again to New York's law?
So they're not looking back because this argument in this case, so I will grant it the discovery rule is based on the common law of California, but this argument, the accrual provision and the repurchase protocol is not really based on California law, it's based on New York law because it's a substantive choice of law.
But the argument is that when you look to California in this case, for purposes of 202, you look to the entire way that California would determine if something is indeed timely, which would include their tolling provision.
You would look to their tolling law, but this is not an argument based on their tolling law. The argument is actually based on the interpretation and meaning of the contract, and New York law is clear on this, and so is California law. Whether or not a contract has a condition precedent is a substantive issue of contract interpretation. And so if you're going to interpret a contract, you need to say, first of all, does the contract have a choice of law provision? These contracts have choice of law provisions. They're New York, and the court actually already reviewed these repurchase protocols. They reviewed an identical accrual clause in a case, mind you, brought by Deutsche Bank. Flagstar brought the Deutsche Bank case with an identical accrual clause. And New York choice of law was, the substantive law was New York, and the court found it doesn't delay it. They can't cite to a single case that says we need to look to California law with respect to how to interpret condition precedents because there's no basis to say that a California court would ignore the New York choice of law provision. It would not, and that's why they lose on that argument.
Thank you, counsel.
You're welcome. Thank you, Your Honor.
Counsel?
Your Honor, there are several things I'd like to clarify. The first is that in DLJ, the court held that the claims accrual on the closing date, not the execution date, because the representations and warranties are made as of the closing date, and that's the critical date. The trust under the restatement 3rd, section 2, that it recognizes that the common law and statutory law implicitly recognizes a trust as a legal entity. And the rule, of course, that you have to look through the representative plaintiff to the actual underlying party that suffered the injury is evident in many types of cases, such as bankruptcy trustees, subrogates, and the like. Here, we're asking that the same rule be applied with respect to a trust, which is created in New York under New York law. The representations and warranties, which are the asset of the trust, it's a separate asset, and that's at A100, A567. That's the asset that is diminished by their breach, and that is made in New York on the date of the closing.
So then who or what suffers an injury as a result of the diminishment of the value of these assets?
Well, Your Honor, the trust suffers the injury, and as a consequence, of course, the certificate holders, because they are the beneficial owners of the trust. It's not the trustee.
The trust invested something that now is worth less?
Exactly. The trust has assets. Among those assets, and they're listed to include the representations and warranties.
The trust purchase assets?
The trust,
Just to be clear.
There may be a bit of a legal fiction here, just as there is with respect to corporations,
indeed.
Your Honor. But in ACE, it specifically says, and repeatedly, page 591, The breaches, quote, caused the trust and the certificate holders to lose $300 million. At page 597, the trust suffered a legal wrong at the moment the sponsor breached.
So then you also see it as the certificate holders have their own kinds of claims, and then the trust has its own claim.
That's right, Your Honor. And the trust provides that clarity that the court is looking for, because the
The only
trust
thing
is
I'm
created under New York
struggle
law.
with a little bit on that is I understood that the trustee is, of course, authorized to bring an action on behalf of the certificate holders.
And that's true in the case of the bankruptcy trustee or the subrogee, any of those representative plaintiffs, that's true. But you have to look through that to the actual injury. Who's
So-
injured and
So
where?
nonetheless, we get back to the problem before, the initial obligation to do something about this, and that seems to have been your obligation.
Upon the demand of the certificate holders.
So
That's
you're
right.
saying the trustee
Or
has, now let me
notice.
just get this straight. You're saying the trustee has no obligation, absence of demand of the certificate holders to do anything here?
Well, no, Your Honor, because.
Because we're talking about every bank in the world is about to collapse. Now, let me just finish. Every bank in the world is about to collapse. We've gone through the largest economic meltdown, are on the verge of it since the Great Depression, and the trustee has to wait for the certificate holders to ask him to do something to try and protect their investments.
No, Your Honor, because the defendants also said that they would provide notice to the trustee upon their discovery, and that would also trigger the obligation.
That's why I initially asked you about whether or not there have been any actions for breach of fiduciary duty, and you said none on this. Is that right?
No, Your Honor. But of course, the defendants can't escape the timeliness of this action by themselves breaching their other obligation to provide
No,
notice.
I
to the
understand your
trustee.
other argument. I'm curious about the inaction here on your part.
So
I do want-
what's the source? Okay, the certificate holders have their own claims. What's the source of the trustee's claim?
It is purely contractual, Your Honor. Under the settlers of this trust are the depositors in New York acting. They create the trust under New York law as a New York trust. The rights and responsibilities of the trustees are solely those that are specified in the contract. They're not supposed to do anything that they are not obligated to do under the contract.
Then again, isn't that going back to it's not really the trust that's suffering any injury? Any action they bring is because someone else or something else has lost value in their investment.
And I think that's why ACE phrases it as the trust and the certificate holders, because the certificate holders are the beneficial owners of the trust. It's not the trustee. The trustee's not going to see a dime if there's any recovery here. It's the certificate holders.
So let me ask you what may seem to be a silly question. So I'm a certificate holder. How do I cash in? What do I do?
Well, Your Honor, in terms of asking that this happen, I mean, you could sell on the market
That's
the
what I mean.
certificate, but
You
with
sell on the
respect-
market.
You could sell the certificate on the
I
market.
go to my broker and say, sell this thing.
You could, yes. But what you can't do, and even the trustee cannot do, is sell the underlying mortgage notes. That's not property of the trustee in any way, because, again, that is all constrained by the agreement. And so to say that the trustee is legal owner of the notes, they have no interest whatsoever. They can't even sell the notes. And I want to make clear that the notes, if we're going to look to the notes, in the NC1 case are in Minnesota, which has a 6-year statute of limitations, unlike California. But with respect to California law, the Smith-Barney case involved a contract that also had a New York choice of law provision. And yet, in that case, the court held that in borrowing the foreign statute, all of the extensions and tolls applied in the foreign state must be imported so that the entire foreign statute of limitations applies, not merely its period.
Didn't address these accrual rules like we have here.
Well, Your Honor, in the DLJ case and in Flagstar, both, the court characterized these types of conditions precedent as procedural, not substantive. So you would pick up the law of California, which is part of its limitations period, because it's the procedural rule that it applies. And Smith-Barney says you have to pick up all of those rules because, of course, the statute of limitations is, in a sense, a balance. New York starts with a very long statutory period, 6 years, and then says, but that's it. We're not going to allow you to extend it, discovery, by contract, anything. California makes a different judgment. They say 4 years, a very short statute of limitations, but then they say you can adjust it by contract through accrual provisions, as it was explicit in the BR1 case, but also through
Don't you have to
conditions
bring
precedent.
that within the 4 years?
That's not a categorical rule. The Mayer case that they rely on says that that is the case where the plaintiff was itself injured and knew of its injury on the moment of the injury. But it says explicitly that it's all of the circumstances. And in the Kaplan case, one of the circumstances that you would look to is have the parties in their agreement suggested that some greater liberality about that. In the Kaplan case, it was at any time language. Here, the language is explicitly saying, trustee, you have no obligation, rely on us. And now the defendants are saying, having said, we represent this, you can trust this, you can take it to the bank. Now they say, nope, sorry, you had to go and do what the agreement explicitly says you had no obligation to do.
Thank you, counsel.
Thank you, Your Honors.